*5 years of inaction. Humanist couples sue UK government over marriage discrimination. 5 years after a landmark High Court ruling declared the lack of legal recognition for humanist marriages in England and Wales discriminatory, two brave couples are taking the government to court. Their lawsuit highlights a blatant disregard for equality and a continued failure to uphold the fundamental right to marry according to one's beliefs. In 2018, the High Court delivered a resounding judgment, declaring the existing legal framework discriminatory against humanist couples. The court explicitly stated that the government's inaction was unacceptable, a sentiment echoed by Mrs. Justice Eadie, who famously declared the then Justice Secretary, Robert Buckland, couldn't simply sit on his hands. Yet, 5 years later, the government's response has been deafening silence. A silence that has profound consequences for countless couples seeking to formalize their commitment through a humanist ceremony. Humanist ceremonies, deeply rooted in ethical and philosophical principles, offer a meaningful and personalized alternative to religious marriage. These ceremonies, often conducted outdoors or in settings of personal significance, reflect the individual values and beliefs of the couple, creating a deeply resonant and memorable experience. The denial of legal recognition for these ceremonies is not simply an administrative oversight. It's a denial of fundamental human rights, a disregard for personal autonomy, and a blatant form of discrimination against those who choose a humanist path. The current legal landscape forces humanist couples into a disheartening choice. Either compromise their deeply held beliefs and opt for a religious or civil ceremony that doesn't reflect their values, or forego the legal protections and social recognition afforded by marriage altogether. This is unacceptable in a modern, progressive society that champions diversity and inclusivity. Adding insult to injury, the government's inaction directly contradicts the consistent support expressed by the Labour Party. Since 2013, every Labour leader has publicly endorsed legal humanist marriage, with frontbench spokespersons repeatedly urging the government to act swiftly. This bipartisan support underscores the widespread understanding that legalizing humanist marriage is not a partisan issue, but a matter of fundamental fairness and equality. Despite the overwhelming evidence and the clear legal precedent, the Ministry of Justice continues to delay, citing the need to carefully consider the issue and review the Law Commission's 2022 report. This prolonged delay, however, smacks of inaction and indifference, a deliberate disregard for the plight of humanist couples who are denied the same rights and protections afforded to others. Humanists UK, a leading organization advocating for secularism and human rights, stands firmly behind the two courageous couples taking this legal action. Andrew Copson, the chief executive of Humanists UK, aptly summarizes the situation. This case isn't just about humanist marriage. It's about the government's commitment to equality and its willingness to uphold the rule of law. The lawsuit demands accountability and justice, aiming to finally secure the legal recognition humanist couples deserve. The fight for legal recognition of humanist marriage in England and Wales isn't merely a fight for a specific religious or non-religious group. It's a fight for the fundamental principle of equality before the law. It's a fight to ensure that all citizens, regardless of their beliefs, have the right to celebrate their commitment with the dignity and recognition afforded by legal marriage. The outcome of this case will have far-reaching implications, sending a powerful message about the government's commitment to inclusivity and the protection of fundamental human rights. The wait has been far too long. It's time for the government to act.